Breaking news now from the Royal Courts of Justice. We've had a judgment in the Dieselgate case. Let's bring in our business correspondent, Paul Kelso, straight away, who is there and can tell us what happened, Paul.
Yeah, this is the Dieselgate case, one of the largest group litigation brought in the UK. More than 1.6 million claimants pursuing a number of car manufacturers, 5 key manufacturers in this case, with the allegation that they had effectively deliberately defeated emissions testing on diesel vehicles, had fitted devices to engine management systems to reduce the diesel emissions when the cars were being tested in an MOT and other such circumstances, and then would be back on the road with much higher emissions. In Germany, people may remember the Volkswagen case, Dieselgate, exposed in the United States. VW conceded liability. Well, we have been waiting for a judgment for the last couple of hours. Plenty of campaigners here are waiting for it too. I haven't seen a copy of the judgment yet, but we do have some reporting from Reuters, the agency which has seen the judgment, and they are saying that the High Court here has rejected most of the principal allegations advanced against the manufacturers. There have been some adverse findings. This reporting from the agency Reuters says that the UK court says in the majority of cases the manufacturers' strategies were not to use defeat devices. So to be clear, in the Volkswagen case, they had fitted devices to the engine management system that were capable of cheating effectively the emissions testing, and the allegation here, the case brought by this huge number of people, 1.6 million people, claimants to this case, was that 14 manufacturers had done the same here in the UK. The judge, to try and simplify this case, there are of course hundreds, thousands possibly of different models of different diesel vehicles sold by these manufacturers. They chose 5 manufacturers, including Ford and Mercedes, Nissan, Renault and Peugeot, which is part of the Stellantis group, and looked at 20 models from those manufacturers to try and establish the evidence was called on whether they did in fact have these defeat devices as they are known. Of course, it's highly controversial and was almost ruinous, frankly, for Volkswagen when it was exposed in 2015, 2016 by academics in the US, because deliberately defeating and fixing your emissions output. This came at a time when governments, particularly in Europe, were encouraging drivers to buy diesel cars because they have much lower CO2 emissions. The concern about CO2 and greenhouse gases then, this emissions testing was about nitrogen oxide, and the discrepancy between what academics found in cars on the road and those when those same VWs were wired up for emissions testing was about 40 times different. So the suggestion in this case that this was routine amongst more than a dozen manufacturers, millions of cars affecting millions of motorists, and of course millions of people in Europe and the UK breathing much greater levels of nitrogen oxide are enormous. This is a very substantial case, but as we understand it for now, still waiting to get a look at the full judgment and see the judge's words here. Reuters, the agency, is saying for now the judge has rejected most of the principal allegations advanced against the manufacturers, which would appear on the face of it to be a defeat for campaigners and lawyers who've been working on this case. It began being heard last autumn. This is long awaited, and we'll have to see what the response is from them, and of course from the motor manufacturing industry across Europe under enormous pressure. The transition away from fossil fuel vehicles, diesel and petrol, to electric vehicles, placing them under enormous pressure. China well ahead in that race. This would have been, and may still have implications for them, but on the face of it, it appears to be that campaigners have lost and the car manufacturers have found not to have been routinely cheating emissions, cheating their environmental claims and cheating public health authorities. But I think we should take a look at the judgment and come back to you with some more detail when we have it.
Certainly, Paul. Thank you very much indeed for the time being. But joining me now is Joshua Rosenberg, legal commentator. Joshua, good to see you as well. 1.6 million claimants in this class action, and they're going to be disappointed at this.
That's absolutely right. They are going to be disappointed. The judgment has come out. It runs to 369 pages. I've got it. I haven't read it, but there is a summary of it. And as your reporter was saying, the court looked at this concept of a defeat device, which is the item that was designed to confuse the testing mechanism. And it looked at the statutory definition of it and the circumstances in which differences between laboratory test performances when the vehicle was being tested and real-world operations may give rise to liability. So in other words, they looked at whether some aspect of this defeat device made a difference to how the car performed under test and how it performed in the real world. And it was agreed between the parties that vehicles were not required to meet the emissions limit set for this type approval test outside the test. The judgment concludes that not every calibration or emissions control strategy amounts to a defeat device. A defeat device is a device which senses when one or more parameters of the test and objectively operates with the purpose of causing control systems to work more effectively when it senses it's being subjected to a test cycle compared with how it works out in test driving. That's extremely complicated, but it's a definition of what this defeat device is. It senses that the car is being tested and it produces a different result from how the car would operate in the real world. For a defeat device to be found, the court said, there needs to be an intention to cause the emissions control system to operate differently when it senses that it's being tested, and it wasn't enough for the claimant simply to establish that the strategies they were challenging reduce the effectiveness of control systems outside the relevant testing systems, and arguments relating to a breach of contract would require fuller evidence before a conclusion could be reached. Now, that's a summary. I can assure you that the judgment itself, 369 pages, is much more complicated, full of technical legal points, full of technical diagrams, full of quite sophisticated reasoning. But as your reporter was saying, I think that the claimants are going to be disappointed, and I think the manufacturers are going to be relieved.
It's interesting, Joshua, and it does sound complicated, and that's just the first paragraph of thousands in that very lengthy judgment. But in essence, what the judge seems to be saying is, sure, these things might have operated in test conditions in this way, but there was no intention for them to operate differently in the real world, even if they did operate differently in the real world.
That's absolutely right. The court rejected most of the principal allegations advanced against the manufacturers whose vehicles were examined at the trial. In most cases, the court found that the relevant strategy did not constitute a prohibited defeat device. It did make adverse findings in relation to certain specific strategies, and it found that if an alternative approach were taken to the meaning of defeat device, then, however, most of the allegations would still fail. But if an alternative approach to the meaning of defeat device was taken, then a larger number of defeat devices would be established, including devices in each of the lead manufacturers' cars. So this is a question of liability. It's been handed down subject to corrections. There'll be a final version later on. There is to be a further trial scheduled for October this autumn to decide the consequences of any breaches that the court has found. But you can be sure that the manufacturers and their lawyers will be poring over this 369-page judgment. They will no doubt be issuing their reactions in due course. But at first reading, it's certainly not the absolute victory that the claimants were hoping for and that their lawyers were claiming that they should be entitled to.
Joshua, this is not a question, and I will ask you one after I make it, but the comparisons with people driving these days will not be lost on anyone who drives a car when they look at the miles per gallon or the miles per kilowatt numbers, far higher advertised than people can ever achieve in the real world. Of course, that's just an observation. It's not a comparison to this case or any accusation of wrongdoing. But it brings me on to my next question. As you intimated there, and not an unmitigated success for the car manufacturers. And also this comes off the back of Volkswagen, which wasn't necessarily part of this action. They did have to pay out tens of millions of pounds themselves. So does that indicate, even though this is mostly a win for this bunch of manufacturers, they may have to pay out something, given it's not 100% in their favour?
I think that's right, and they may well want to settle this case now they've got this judgment, but obviously any settlement would be for far less than Volkswagen actually paid out. Clearly, it is a substantial victory for the manufacturers as far as one can see, and so if they are going to settle these claims, they certainly won't pay as much as Volkswagen did.
OK. Joshua, thank you very much indeed for your time.